Now, I'm here today to talk about the legal problems in the Obama administration's so-called Clean Power Plan, commonly known as the 111D rule. This rule seeks to require states to reduce emissions from existing coal-fired power plants by, on average, a staggering 30% over a 15-year period. Now, make no mistake about it, finalizing this proposal would have a devastating impact on my state, other coal-producing states, and citizens from across the country who will feel the negative impact of high electricity prices, lost jobs, and a potential lack of reliability in the power grid. Now, West Virginia is one of the poorest states in the country, and yet we're the second largest producer of coal. It's a very important resource for us. This proposal will result in even greater economic dislocation in Appalachia at a time when we can least afford it. Now, it's my duty as the chief legal officer of the state of West Virginia to fight against this unlawful power grab, which is hurting our citizens. West Virginia has already led a bipartisan coalition of 15 states before the U.S. Court of Appeals in D.C. And if this administration elects to finalize this rule, West Virginia will challenge it in court, and we expect that the coalition of 15 states that we're currently working with will grow. Today, I'd like to talk about just a few of the legal defects of this proposal. Now, as you all know, the EPA bases its claim for legal authority to adopt this rule entirely on Section 111D of the Clean Air Act. However, a nearby provision, Section 112 of the Clean Air Act, EPA prohibits the agency from invoking Section 111D for any pollutant, quote, emitted from a source category which is regulated under Section 112. We think that language is very clear. And as EPA has repeatedly explained time after time, this text literally means that if EPA has already regulated a source category under Section 112, EPA may not then come in and require states to regulate any pollutants emitted from the same source category under 111D. Now, this is where the EPA runs into some trouble because, as we know, in 2012, they already finalized a major rule affecting coal-fired power plants under Section 112. Now, the EPA's legal argument for avoiding this Section 112 exclusion is not credible and defies all traditional rules of administrative law and statutory construction. And let me explain. When Congress enacted the present version of the Section 112 exclusion in 1990, they actually made a mistake. It accidentally included two provisions in the statute at large, two amendments to the same exact text. One was a substantive amendment that replaced a cross-reference and changed the exclusion to its present form. The second was a conforming amendment, a technical amendment, if you will, that was made 107 pages later. But once you actually applied the substantive amendment to the text, it made the conforming change wholly unnecessary. And that is why the technical error was never included in the U.S. Code. Now, what happened there is actually consistent with the way Congress has always operated. To the extent that there are clerical errors in a text, when Congress goes back through the revisers to decide what goes in the code, they analyze that, and they apply traditional rules of statutory construction. And in fact, we've never seen a situation before where a federal agency has literally tried to push such a sweeping proposal on the basis of a typo. It's unprecedented. But perhaps the most radical feature of Section 111D rule is its sheer breadth. Rather than follow the traditional pathway of opposing an emission rule on a particular source category to make that source category more environmentally friendly, the Section 111D rule requires states to replace coal-fired energy with other sources of energy and even reduce consumer demand for energy. That means that the Section 111D rule seeks not only to regulate power plant emissions, it's a mandate for states to fundamentally reorder their electricity sectors and pick winners and losers between those sectors. This rule would regulate from power to plug. Now, as Allison Wood, a well-respected attorney, recently indicated before the House Energy and Commerce Committee, the EPA's claim here is analogous to the agency asserting that its authority to regulate automobile emissions provides it with the power to order citizens to take a bus to work or buy electric cars on the theory that the measures would reduce car emissions. Section 111D simply does not grant the EPA such broad, sweeping power. Thank you very much.